the Institute of Intellectual Property and Social Justice, who is running things with Zoom. And we want to welcome our next panel. Charity is going to be our moderator. I'm going to get going just as soon as we get everybody in. And you guys, Rizzy, I just love you. Rizzy for president, you all. All right.
Go for him, go for him.
Take care. Let's go, Charity.
Hey, Charlie. Hey, everyone. How's it going? Really excited to have everyone to come and join this panel discussion and to talk about key issues regarding these different data privacy regulations. So my name is Charity Ogbeide. I am a principal in the Privacy and Data Protection Group within Promontory, a IBM business unit. And today we are going to be discussing the CCPA and other key data privacy regulations. We want this conversation to be fun and educational, so please feel free to drop any comments or questions that you have, and we will address them during the Q&A portion. So before we get started into the discussion, I am excited to introduce our lovely panel. And because, for those that work in privacy and tech, we like going above and beyond. So I'm going to introduce each panelist. And after I introduce them, they're going to tell us about how they encounter privacy in their day-to-day life within their career. So to get it started, I'm happy to introduce first Dominique Shelton Leipzig. Dominique is known for asking deep questions that provoke transformative answers. As the chair of Perkins Coie's Global Data Innovation Team and co-chair of Perkins Coie's AdTech Privacy and Data Management Practice, she focuses on privacy, data strategy, leveraging data, and avoiding litigation, which she knows a lot about. Because she was a litigator for 22 years and has been counseling for another 9. When you need an expert, you want the person who wrote the book. Dominique's landmark book on the CCPA has recently been published, a new edition, and she pioneered the concept of data as a pre-tangible asset in which she calls our post-data world. Dominique represented the California Chamber of Commerce in a 6-week-long negotiation with Alistair McTaggart, his lawyer James Harrison, his consultant, former FTC technologist Ashkan Soltani, and Senator Hertzberg regarding the CCPA 2.0 and many of the business-friendly terms which were obtained through those negotiations. She's trained over 18,000 professionals on the CCPA. She is a member of the IAPP board and a leading advocate for data ethics. Her commitment to active integrity extends to all of her work, which is why we're especially happy that Dominique is with us to join this panel. Dominique, it's a pleasure to have you. So could you briefly just tell us about how do you encounter privacy in your day-to-day work?
Well, I spend a lot of time counseling these days CEOs and board members about how to lead in their data. And I caught the end of what Chanel was talking about, and it's precisely for those reasons. So privacy is what I do 24/7, think about 24/7, and try to help clients think about how to lead in their data. And rather than sort of waiting for the next privacy ball to drop, I started our global data innovation team at Perkins so that we can speak directly to officers and directors to help them understand the importance of the 150 countries that have data protection laws today, and the fact that our 2.5 quintillion bytes of data, that is basically 1 quintillion second is 31 billion years. So we are generating 2.5 quintillion bytes of data per day globally, and we just need a structure and leadership to address it.
Yes, that's awesome. Thank you so much for that insight, Dominique. So this I'm happy to introduce our next panelist. So I would like to introduce Ali Jasoni. Ali counsels clients on the privacy, cybersecurity, and regulatory risks presented by new and proposed uses of technology and consumer information. Specifically, he advises clients with compliance issues related to the California Consumer Privacy Act, the General Data Protection Regulation, and other federal and state laws governing data sharing, ownership, and protection. Mr. Jessani also guides companies through legal obligations after data breaches, as well as through state and federal regulatory investigations. Thank you so much for joining us, Ali. Could you briefly tell us about how do you encounter privacy in your day-to-day career? Oh, Ali, I think you might be on mute. You got to unmute.
Sorry about that. Thanks, Charity, and very happy to be on the panel today. As Charity mentioned, I'm a privacy and cybersecurity lawyer at WilmerHale. One of the great things about this practice is how varied it is, and one of the great things about privacy and cybersecurity is how much you can do, and I really get to experience a lot of that in my practice. My day-to-day can span between assisting companies in investigations and in front of various federal agencies like the FTC or HHS. I assist companies in privacy and security diligence on deals. And then I also do general counseling related to some of the things Charity was mentioning, CCPA, GDPR, and some of the newer privacy laws like in Virginia, Colorado, and now maybe in Utah. So another great part of this is staying on top of everything that's going on. So happy to be here and share my experiences.
Awesome. Thanks for the information, Ali. So just moving on to Charnay Augustin. Charnay is a corporate attorney with 10 plus years of in-house legal experience supporting clients in the media, entertainment, and technology industries. Charnay currently serves as senior counsel on the mobility operations and product counsel team at Uber, where she primarily supports Uber's ride-sharing marketplace teams, which designs and operationalizes the technology for pricing and matching riders and drivers using the Uber app. Prior to joining Uber, Charnay served as an associate principal counsel in the legal department at the National Geographic, where she provided support for the company's television productions, including but not limited to drafting a variety of contracts and working closely with the company's production management teams on any legal issues that might arise from the inception of a new television project throughout the life cycle of the show. Prior to her work at the National Geographic, Charnay served as counsel, consumer marketing, and advertising practices at Sprint, now T-Mobile, and prior to that, assistant general counsel at Radio One, now Urban One, a multimedia broadcasting company that owns and operates 53 radio stations in 14 markets, whose other media interests include TV One, Interactive One, and Reach Media. Charnay is a Maryland native and a graduate of both Hampton University, let me get it correct, Hampton University and Howard University School of Law. Charnay, could you briefly tell us just about how do you encounter privacy in your day-to-day career with the things that you do with it?
Sure. Hi, everyone. Happy to be here. I think I'm a little different than a lot of my fellow panelists in that I'm not a data expert, privacy expert. But what I do in my day-to-day is I have to be able to identify when there's a new proposal, a new product, or a new initiative that might have some privacy concerns. So at a baseline, I have to know enough to say, hey, guys, I think the thing that you're proposing, the thing that you want to do, this might, be a concern from a privacy standpoint, and it's up to me to work in tandem with our legal subject matter experts, everyone on this panel, all of the privacy experts to ensure that our business objectives don't run afoul of both our privacy policies and or privacy laws in general. So I'm a little bit of an outlier on this panel, but I'm happy to jump into the discussion and talk more about, how privacy affects the work that I do in counseling my clients in the business.
Awesome. No, thanks for that information. We're excited to hear more about the work that you're doing. So moving on to our fourth panelist, Rizzi Qureshi. Rizzi represents corporations and individuals in government investigations, criminal and regulatory proceedings related to civil litigation. He's an accomplished litigator and seasoned trial lawyer who has tried over 30 cases and has unique experience in successfully representing clients that are subject of complex investigations with the Department of Justice and other domestic and international regulators. Rizzi actively engages in social justice and civil rights initiatives, and as part of that work, he partners with nonprofits and firm clients to advance criminal justice reform. Rizzi also maintains a substantial pro bono practice. His recent representations include successfully securing post-conviction relief for a formerly incarcerated client in Pennsylvania withholding removal on behalf of a Haitian asylum applicant, and representing a client on Alabama's death row in his capital appeal. Rizzy, it's an honor to have you. Could you tell us some about the work that you're doing and how you encounter privacy within your career?
Sure, thanks, Charity. And Charity, you almost made a huge mistake at the beginning when you confused one of the HUs with the other HU, talking to Charnay. You know this audience is tough on that front. And I'm not going to even joke with Charnay what the real HU is. But so, thank you for that great introduction. As you all know, first of all, I'm a proud graduate of Howard University School of Law, and I'm so excited to be a part of this important event. So unlike Dominique and Charnay and Stanton, who you'll hear from in a moment, and Ali, my panelists, I'm not an expert in privacy, but my experience is as a former prosecutor. I was in the cybercrime section at DOJ and the U.S. Attorney's Office here in DC. So my focus is a lot on data breach investigation. So I'm somebody who comes in oftentimes when stuff goes bad. It's either, it could be a foreign actor intruder of some nation state that's acting funny with clients' cybersecurity and stealing data, as well as just individual actors. So my practice is both an investigations practice, but also a compliance counseling practice. So to give you an example, a big healthcare client of mine recently was the victim of a ransomware attack. And from my perspective, where I get involved, it's twofold. As Dominique and others will tell you, the CCPA and the CPRA have created mechanisms by which, there are reporting obligations that not only exist for potential clients and customers whose data you possess, but also to regulators. My job is to not only come in to conduct the investigation to see how widespread this problem is for the client, but also to advise the client, frankly, on how to preserve privilege. Because when we're conducting these investigations, my objective is to get in early, to do what's called a Coval-style investigation. I hire forensic experts and have a whole data privacy and data breach team that works alongside me to ensure that we preserve privilege, because I also know that the CCPA and the CPRA, at least the two statutes we're discussing, provides litigants a lot of power to file suit. And my objective is to ensure that we can conduct an investigation, advise a client about where the vulnerabilities are, where the potential exposure is, but also ensure that I don't have to turn that over to plaintiff's counsel because there are a lot of lawsuits coming down the pike. So, the way I see this, and as everybody knows, and I think a lot of my panelists can speak to this, what's happened under this new administration is there's a stronger focus on corporate misconduct and corporate liability and ensuring that corporations are doing their fair share. A very different sort of perspective as compared to the last administration. To give you an example, one of the things I'm doing for a client now is the DOJ just announced, Lisa Monaco has done a lot of interesting things, where there's a civil cyber fraud initiative, where the government is prepared and the DOJ is prepared to leverage the False Claims Act, for example, to essentially sue companies that do not do their fair share of reporting breaches, especially if you're a government contractor. And where I operate in DC and New York, essentially everybody is a recipient of some government funds that could be brought in under those statutes. So my job is to counsel clients when a breach occurs, to guide them through it, identify where there's exposures, what notifications need to be made to what government agencies, and also to provide them advice moving forward on how to prevent these types of breaches from occurring, so that experts like Dominique and Charnay and Ali and Stanton can come in and really provide that advice before bad things happen. So thank you, Charity.
Got it. No, thanks for that information, Rizzy. So just to go to our last panelist, Stanton Burke. Stanton counsels clients on a broad range of regulatory matters, including data privacy, data integrity, and cybersecurity. Stanton has advised clients regarding compliance with the FTC Act, the GDPR, and the CCPA, coordinating correspondence among client business units, including IT, HR, management, and legal teams. This includes conducting data mapping, advising on data transfers, assessing the value of data, drafting privacy policies, creating data subject request portals, and advising on the use of behavioral ad targeting, and drafting formal briefings to data protection authorities. Stanton earned his Bachelor of Science from Trinity University and his JD from Howard University School of Law, class of 2017. He wanted me to call out Section 3, so we have Section 3. And his LLM in Law, Technology, and Entrepreneurship from Cornell Law. Stanton, it's a pleasure to have you. Can you tell us about how you encounter privacy in your day-to-day as well?
Yeah, thanks, Charity. This is a great question because, you know, privacy is just a very multifaceted area of law, and you can tell from all our responses. I was almost hesitant to be on this panel because of just the sheer volume of legal talent. I was afraid the universe would be disrupted in some weird way. But no, I'm thankful that Charlie puts on this event every year, and you know, happy to talk about my experience. I think to Charity's point, most of my work is advising companies on compliance with data protection laws like GDPR, CCPA, and other, you know, industry-specific regulations. And I often get the question from clients, you know, can we do ABC with XYZ data? You know, what additional parameters need to be in place to launch this, you know, product or service? Or, you know, maybe they're looking to use some vendor and they want to understand the privacy risk associated with that. That's probably about 60%. There's 70% of my work, and the other 40% is probably split between tech transactions and M&A deals. So for tech trans, I'll advise on, you know, the IP sometimes, but mainly the privacy and cybersecurity aspects of agreements with vendors and SaaS providers and other partners, and help negotiate those terms. And then for the M&A side of the house, my job is vetting companies and cybersecurity programs prior to any merger and acquisition. So, for example, if I'm representing on the buy side, you know, I may check whether the target has suffered any data breaches, whether it's been fully remediated. You know, like you think of like the Verizon purchase of Yahoo, you know, that price got reduced by almost $400 million due to the data breach in the middle of that negotiation. So it does have a real impact. I'll also look for any commitments the company's made, you know, in their privacy policy with regard to how they handle data. Sometimes companies make statements like, we'll never sell data, or we'll only use data for XYZ purposes. And, you know, if the company's buying that company, you know, they would have to uphold, in most cases, those commitments. And so it's understanding that privacy touches all of these different areas is helpful as you know, start to maybe build your career in this space.
Awesome. No, thanks for that information, Stanton. So we thought it would be a great idea, before going into discussing the different data privacy laws, we thought it would be interesting and able to add a little bit more context and depth to the conversation by first talking about what led to the passing of these different privacy laws, whether it's on the state side or just some of the different global international laws that we've seen in different jurisdictions. So one of the first issues that we wanted to discuss is some of the AI issues, where we see many organizations using certain tools and technologies such as predictive algorithms or even facial recognition technology. So Dominique, could you just tell us a little bit about some of these AI issues that you're seeing when working with clients, or just generally, that has led to some of the passing of the different privacy laws that have come into effect?
Yeah, so thank you so much, Charity. That's such a great question. And a lot of the impetus, I mean, I'm sitting here talking to you guys from Los Angeles, and having the opportunity to negotiate over 6 weeks with the proponent of the CCPA, Alistair McTaggart. I can tell you a lot of what he was concerned about, and the impetus for even this CCPA, which is the first comprehensive privacy law in the United States to be enacted ever since June 2018. He was concerned with targeted advertising that was being developed using a lot of AI and algorithmic behavioral profiling in order to reach individuals. And he was concerned about that. And that is what really motivated the initial proposition. And he got enough signatures, nobody saw it coming. And then the legislature really had to pivot quickly to get it turned into a law so that at least it could be amended. Ultimately, it wasn't amended very much, but in CPRA, and I just dropped into the chat, you guys, where you can get my book, which is on the IAPP website. There's a whole discussion here about what was motivating him. He's really worried about children being manipulated, sort of our society and politics being manipulated by just one view or another, and then opportunities like certain types of loans, certain types of pricing and health care being sort of targeted to certain groups with inaccurate information. Ashkan Soltani, who is now chairing the California Privacy Protection Agency. He's not chairing it, I'm sorry, he's the director of the California Protection Agency. And he that is the first data protection agency in the United States that's just devoted just to data protection. He's passionate about these issues. I've had the opportunity to talk with him one-on-one, and this is the top thing he is concerned about is the algorithmic bias, algorithmic fairness, and targeting that might result as related to advertising. So this is the algorithms are really at the crux and core of what's going on. And with California, that's where Virginia, and then, well, basically, let me just say in negotiations, Alistair told us in 2019 when he was doing CPRA and we were trying to get him to put some business friendly terms in, he told us he had talked to at least one legislator in every single state in this country, was prepared to introduce a bill similar to CCPA or CPRA, depending on whether CPRA actually got enacted. So now you're going to see bills popping up like popcorn. There's a couple others I just saw this morning. So you just get ready for this and put your seatbelt on, because we are going to be seeing the states take over because we don't have federal privacy law yet. So thank you, Charity.
Yeah, no, that's a great information perspective in regards to seeing the more proliferation of laws passing from what's going on with the activity that we're seeing in California. Charnay, I know you also encounter some of these different types of issues in regards to the use of technologies within your line of work. Could you tell us about some of those issues that may have, what's leading to the passing of privacy laws at the state and federal international level?
Sure. So I think a lot of people wouldn't even maybe think about this in the terms of like ride sharing companies. But one of the things that made ride sharing companies attractive to consumers was that you could put in your destination, and like unlike taxi drivers who would try to avoid going to certain neighborhoods or didn't want to take you once you told them your address. This is something that, with these rideshare companies that you didn't really have to worry about. You could put your address in, and that information at a point was not being shared with the drivers until a certain point. They just were taking you to your destination. But as these companies were changing and evolving, I think Lyft even does it now. I think Lyft actually does now show drivers your exact address and where you're going. And so by now sharing this kind of information and sharing this data about you, this now causes a concern for what's known as destination discrimination. And people don't think about some of these adverse effects that the use of something as simple as providing your address to a company or where you're going and how they're sharing it and how they're using it. This can have, effects on generally underserved communities and communities of concern, and where people are going. So, this is another thing now that both Uber, other companies like Lyft have to keep an eye on by sharing, upfront where customers are going, if that's going to cause any sort of degradation to the service that our consumers are receiving. And if we're seeing, now drivers avoiding going to certain places because they now have this data up front, are drivers going to be avoiding going there or not wanting to go there? So now we have to put policies in place to monitor how this data is being used and what these drivers are doing, and have systems in place to kind of address that when we see it happening, and have a process and procedures in place to address it, to make sure we are not, contributing further to this issue that, was the goal to avoid, as one of the reasons that made, ride sharing so, popular and effective. So that's just another thing that I think that people don't even think about in the context of like how we're using customers' data and how it can kind of be used adversely when, you're not even realizing it. So just another example, to piggyback off Dominique.
Charity, can I piggyback off of Charnay now? And I know Charnay's speaking from the ride sharing perspective at Uber, but as I noted, I do a lot of compliance counseling, and one of my clients, which is not a ride sharing company, but very similar to the equivalent of Zipcar. So, a company where you're going to go rent a car for a few hours. And as you all know, a lot of rental car sort of providers are often very concerned about the use of their vehicles for criminal conduct. I mean, it's very common that rental vehicles are often used to conduct criminal behavior because, you know, it's hard to trace, especially if you're utilizing somebody else's credit card information. But one of the things that I had to advise a client on, what the client didn't appreciate at the time, and this is where people like Charnay and Dominique and Ali and Stanton can come in with their expertise, is, you know, the client wanted to include certain criminal history, criminal background check requirements as part of their user agreement, which would require them to essentially look at the criminal history, and they were hiring a third party to conduct those background checks. Now, there are specific, and obviously I'll let the experts speak on this, but there are certain required notifications that must be made to the consumer under the CCPA if you're going to run a criminal history check on him or her. And there's some pre-notification requirements that the company needs to put in place to ensure that they don't violate the CCPA and expose themselves to additional litigation. So just another thing to think about of why these laws are so critical, because it creates, frankly, a much more equitable approach and treats most, and attempts to treat all consumers of all backgrounds, you know, on a level playing field. At least they aspire to do so. And that's just one example of ensuring that when you're running criminal history background checks, you're not unnecessarily discriminating against a certain class of people just because you have some criminal history that is completely not relevant to whether you're going to be a responsible user of the vehicle in question. So something to think about as well.
No, thanks for that information, Rizzy. And that kind of brings us into the next issue topic with regards to just the handling of sensitive information, specifically biometric information, where over the last few years, where we've all seen individuals who have having to submit information to their employers regarding their COVID-19 status. If you're trying to go on certain flights to certain countries, you're required to submit your COVID-19 vaccine, whether you're vaccinated or whether you've gotten a COVID test. So Dominique, can we talk a little bit about the purpose limitation issues that occurs with that? Whether if a person submits this type of biometric information to their employer or to an airline, or whoever it may be, are we seeing this information being used for different purposes? And what are the issues that can occur with that?
Well, that is, you know, one of the big issues that we're trying to get our arms around. Certainly the consumer advocates and others have been, and just everybody really as individuals wants to make sure we know where this data is going and how it's going to be used, and for the limited purposes that it should be used for already. We've seen situations where I think it was one of the Dakotas, they had an app that the data that was being uploaded for vaccine status was supposed to be just going only to the government. That's it. No other place was it being shared with. And sure enough, and you know, unfortunately, the app was developed with on top of a software developer kit, where it was graphed and was basically sharing the information with Foursquare. So could that data then later be used to target, you know, certain on the benign area, certain products, or could it be used or sold for other reasons? And so there's a lot of concern about that. And that's why insurers need to be really careful about the metrics they use, and also the algorithms that they're creating that might be based on some of this information. And this is really what CPRA, for example, is by having that definition of sensitive information that ties in to what the Europeans have done in Article 9. So things like health information, biometric information, but also race, gender, sexual orientation, religious and political point of views are now all part of California's law. And with the 5th largest GDP in the globe, a lot of what we do in California impacts the entire country. But you know, this is a really sensitive area where steps need to be taken, and this is really comes down to the conversations I'm having with a lot of officers and directors now about brand, value, and trust. in those 2.5 quintillion bytes of data, a lot of it these days generated by the COVID pandemic, and how that information is going to be used for good. You know, you want to use that data in some instances, be able to stave off new outbreaks, understand when things are coming in, but making sure that that is not coming out to be used to say, we will not hire somebody who might have predilections for X, Y, and Z, or there's insurance issues in underwriting with X, Y, and Z. So these are all the thorny issues we're grappling with. And that's why I'm so excited to be here and that the students are here, because you guys are going to be the ones helping us figure this out.
Yeah, I mean, yeah, from what you said, it sounds like organizations need to have a understanding of the data that they're collecting, storing, but more importantly, how it's being used. Because if, like you said, if it's being collected for one reason, then those multiple other uses is something that the consumers or individuals need to know about.
Exactly.
Gotcha. Thank you. And I'm happy that you brought up SDKs, because that kind of brings us to the final topic in regards to what led to the passing of these newer laws, which is in regard to the ad tech industry, where we know this industry is worth around like $137 billion and is expected to reach $630 billion by 2024. And we've seen a lot of activity over the last few years with the DPAs initially back in like 2019, 2018, releasing guidances regarding their expectations. And then we had the seminal Planet 49 case. And then afterwards, you started to see fines coming into effect for certain organizations. So Ali, can you just briefly provide an overview of some of the issues that are going on within the ad tech space and how the CPRA and the GDPR have been working to help to reel in some of these issues?
Yeah, absolutely. I think Dominique did a great job talking about how important targeted advertising was to the initial passage of the CCPA in the first place. You know, targeted ads, they're one of the most concrete ways in which, you know, privacy becomes like a real issue to all of us. You know, all of us have Instagram. Well, it'll be times where you'll be thinking about something, right? And you'll see an ad about something you were just thinking about seemingly. And it's like, and it's one of those areas that for the longest time was completely unregulated because we didn't treat that information, the relevant information that entities were collecting, as personal data. Things like cookies and IP addresses generally fell outside of our relevant privacy laws. And now with comprehensive privacy laws like the GDPR and CCPA, you're seeing this information becoming more regulated. And one concern that's, you know, particularly driving regulators is data brokers, right? Entities that are consistently whose business is to buy and sell data, right? These entities where they're constantly collecting data from harvesting data from things like your phone and your computer. This will be, and as you know, we were talking about purpose limitation earlier, this is information that's not tied to your use of a service at all. Like, for example, right, like a common example given is like the flashlight app on phones that used to exist would collect location data. And it's like, well, it's completely irrelevant to the use of the service, but that's how the app that was free would make money, right? It would sell that data to data brokers. Data brokers would, you know, repackage it and sell it to advertisers. And so we're seeing this industry at least have to comply with some, you know, some, what used to be the Wild Wild West, at least have some requirements applied to it in terms of the CCPAs do not sell obligations for businesses that sell information. And now with the CPRAs limit the use of my sensitive personal information requirements. So there's still a lot of work that needs to be done, but at least the industry is facing some regulations where it previously didn't have any.
I would just say, you know, this is such a huge issue when you're looking at a third of market cap that just, you know, disrupted the market just last month to the tune of $300 billion lost in market value. And just based on $10 billion miss in ad revenue, based on what Apple has done to require opt-in consent for tracking. So this is a live issue. It's a huge issue. It's just disrupting the entire ad tech industry and in some respects undermining or getting in the way of what the sort of free to consumer internet model. How's this going to work? And just level setting on what's going to be acceptable. So I think this ad tech industry is really in flux right now, how they're going to replace the cookie, especially with Google coming out with an announcement pretty soon, or just last week, I think, that they're going to be deprecating in 2023 third-party cookies. So a lot of, for you guys as students, when you come out, a lot of the companies you'll be interacting with will be rethinking and reimagining their ad tech models.
Yep, thanks for that additional information, Dominique. And Ali, we know with the different privacy laws that have passed, whether it's at the state level, the CCPA, Virginia CDPA, and Colorado's privacy law, but then other international laws such as the GDPR and LGBT, there's typically some overlap, whether it's sometimes within consumer rights, individual rights, or just business obligations. So Ali, can you just walk us through at a high level some of what these laws are saying and what are the key obligations?
Yeah, absolutely. Let me share my screen here. Can you all see my screen of the slide? Great. Yeah, so as Charity was mentioning, there are some key themes that kind of touch on comprehensive privacy laws, and I'll kind of walk through some of them. And, the specific requirements in each of these laws vary depending on, their priorities and the things that, they want to emphasize. But what I have here is a general overview of things that are, relevant in all of these laws. So starting with a broad definition of personal information or personal data. This is something that I was touching on earlier, where a lot of information that was previously regulated in the US in particular fell outside of the scope of the relevant laws. In the US, historically, we've regulated privacy from a sectoral approach, where we have the Gramm-Leach-Bliley Act, for example, for financial institutions, and HIPAA for certain healthcare data, CAN-SPAM for emails, TCPA for text messages, things like that. Now we're starting to see comprehensive privacy laws that apply to all personal information or personal data that entities are collecting, and this definition is including things like cookies, IP addresses, persistent identifiers, things that aren't traditionally thought of as personal identifying information, but are now regulated under these relevant laws. We're also seeing individual data subject rights. So these are things like the right to access, right to deletion, the right to correction. And these are creating unique challenges for both businesses and but creating it's a good thing for consumers to have this ability. And then we're seeing some laws will be more specific, that like the CCPA's do not sell obligation. We're seeing specific notice obligations. So as Charity had mentioned earlier, a lot of these things are included in privacy policies, but we're seeing more specific notice obligations than that. So like notice at collection requirements under the CCPA, or a notice as part of someone choosing not to sell their personal information. We're seeing downstream contractual obligations, and so an example of this is like a data processing agreement, where a company that hires a service provider has to include contractual provisions with the service provider that limit what they can do with their personal data. So this provides an additional level of protection to a consumer, where in order for their they can provide their information to a business and still expect the business to expect entities to whom the business shares that information with to treat that information consistently with how they provided it in the first instance. We're seeing opt-in and opt-out requirements for certain processing activities. So again, an example of this is the CCPA's do not sell my information requirement. And we're seeing the new laws in Virginia and Colorado, including opt-outs for certain processing activities, such as targeted advertising. And so this is becoming, the premise here being that certain processing activities consumers should have more choice over, because they're not necessarily related to the services that the consumers are choosing to provide their data for. And then we're seeing, privacy by design provisions being incorporated in law. Privacy by design refers to the notion that privacy, instead of being a back-end obligation, should be built into a business's core function. It should be something that the business considers from start to finish when launching a new product or its services. And so an example of this would be, purpose limitation, what Dominique was touching on earlier, where a business limits the use of the personal information it receives to the products and services that the consumer is requesting. Another example is data minimization, where the business only collects the information it needs to provide the services that the consumer is requesting. These are generally good practices that businesses should implement to be privacy protective and privacy considerate for their consumers. And then we're seeing reasonable security requirements, right? Like we talked a lot about privacy specifically, but privacy and cybersecurity are two sides of the same coin, where part of protecting someone's expectations of what's happening with their data is protecting it from unauthorized access. And then, we're seeing a lot of at least some overlap in some of the privacy laws where the CCPA, for example, creates a limited private right of action, as Rizzi was mentioning earlier, but this private right of action focuses specifically on data breaches. And so, that's another area where we're seeing a focus on some of the privacy laws.
Hey, Ali. The one thing I'll add, that only because I'm doing them all the time, is risk assessments. Like most of these privacy laws will require you for certain data processing activities, if it involves sensitive data or if it's a high risk processing activity, you're using AI, you'll need to conduct a risk assessment, impact assessment, legitimate interest assessment, sometimes a transfer impact assessment, and then oftentimes a DPIA. So it's like acronym soup trying to, figure out all the different risk assessments that you need to do for your processing activities. So that's another theme I'd add.
Absolutely. I think increased documentation overall is becoming a common theme, more accountability by taking into, by doing these risk assessments and documenting your data practices.
Yeah, and I would just feathering on to what you guys said, Stanton and Ali, and that was a great overview, by the way, Ali. You broke down all the laws so quickly. So students, this is amazing. But, with respect to the risk assessment and the importance of that, lots of times you might even, when you start practicing, and I don't know if you experience this, Stanton, where clients will say, why do we have to write a legal memo to what does this have to do with actually running our program? And the reason that it is so critical when, and just, piggybacking off of what Rizzi was talking about, once you're dealing with regulators and you are in the trenches with them, I can't tell you how many times I've been before the California State AG's office defending clients against a notice of violation or otherwise. And they will, when there is an investigatory subpoena, they want to see, well, where are all your policies? And then what is the risk assessment that is associated with them? So I have been in meetings that, in fact, some of them are public that you can search for, where literally all you can see are the regulator's eyes. They've, back when we were in person, with the stacks of documents the clients had already produced about their program. And when there was no risk assessment to hang those policies to, they just literally physically moved them to the side and said, we're just going to start over because you could have copied these from anywhere. So we don't know what these policies are tied to and what risks that are in your thing. So we're going to start from scratch and we will do the risk assessment. And then you don't want to be in that place, because then all of a sudden you've got the regulator who's new to your business making decisions about what you should have mitigated. And so it's in the absence of an analysis, an assessment like Stanton conducts, like he said, every day, is where you see these 10, 20, 25-year consent decrees for 8 figures, 9 figures, et cetera, emanating out of our data protection authorities in Europe or in the US at the FTC. So just want to say how critical that point was about the risk assessment being there.
No, thank you both thank you all three of you for that, for the insight and that information. And just going into some of the laws that Ali just so eloquently broke down for us. Charnay, I know that with the work that you're doing in regards to consumer protection, you sometimes run into these laws and have to analyze them in order to determine how to protect the consumers that you're working with. So could you tell us a little bit about your experience in regards to that?
Yeah, sure. So I think a lot of, the ones I've come across, especially when I was at Radio 1, I think back in 2018, there had just been some updates to the TCPA, the Telephone Consumer Protection Act. And, radio, I worked in the radio business and, it's heavy on sweepstakes, contests, sending out, text messages, all that. We had to completely revamp, everything we're doing. And now you have to come in with this opt-in, opt-out system. So that was like when that first started. It was really interesting to be a part of that, and restructuring, how we're structuring these contests and sweepstakes and how we're contacting listeners. Even with our contests and sweeps, then COPPA, the Children's, Protection Act, making sure you're not collecting data from kids who are under 13. So a lot of these new changes came, and we had to like adjust how we were structuring things, how we're reaching out to customers. Even now currently, or even when I was at Sprint, the TCPA was a big deal then, because just because someone has given you their phone number or their information for one thing does not mean that you can just use it to do whatever you want or to contact them about whatever you want. I mean, there were even fines being given for people being texted about account updates. If I didn't consent to I don't want any text from you. So even account updates, you could have been fined for those things. So those are things that I've had to counsel on, and just being clear about what, the privacy policies are and how we're using, either customers' information. Now, even in my current job, we send a lot of surveys to drivers to get, their feedback on things. A question came to me, hey, we want to contact these drivers and call them and ask them if we can, ask them some more questions about X. And it's, well, someone asked, well, is this in line with our privacy policies and how we're allowed to use these drivers' information? Because I think they only had limited information about them and then wanted to go in and further get some more stuff to take it and use it. So I had to go contact privacy and say, hey, this is what our team wants to do. Any concerns from a privacy standpoint? And then I realized we actually didn't have the proper language we needed on that survey about how we would be using their information, whether or not they want to consent to being contacted as a result of filling out this form. I think those are a lot of things that people don't think about. Even apart from targeted ads, there's a lot of crossover, I think, between privacy and marketing. For example, let's say the business comes to you and says, we're doing a partnership with X company. We're going to take all of our customer data and give it to that company so that company can reach out to them and do whatever they want. Like, that should raise a red flag for you if you're the counselor, you're the lawyer working on that. Hold on, what do our privacy policies say about how we use customer data and whether we share with third parties or whether we do not? My company, for example, we do not share with the third parties. So if a business client came to me and said they wanted to do that, I would need to be able to be like, wait a minute, I think we've got a privacy issue here, or just any issues that you see that, might involve privacy, you've got to be able to issue spot those. So that is kind of how it comes up for me in a lot of instances, and kind of in consumer protection and how we're dealing with customers, and, a lot of the different jobs I've had and how we're interacting with customers.
Yeah, no, yeah, thank you for, it just seems like what you just described is just the impacts of those different privacy laws and how they affect the business operationally. So Stanton, can you tell us about some of the other impacts that you're seeing and how with your clients, and how these different privacy laws are affecting whether it's their business model, their operation, or just from a public image standpoint, whether it's positive or negative?
Yeah, no, that's a great point. And I think we've pretty much said a lot of the impacts. As Dominique noted, there are 2.5 quintillion bytes of data being generated. I mean, a lot of that's personal data, and countries are paying attention. By 2023, we expect over 70% of the world's population to be under some data protection law. Like, that's huge. So we're at a point now where laws are relevant for everybody, and every company is thinking about the personal data that they ingest and transfer, how that's being monetized, how they can leverage it for products. And the regulators are watching like the real world impacts that this could have on people, whether you get a ride home or not, whether you get credit, or you're seeing more targeted ads. And so, data is the kind of underlying factor of all this. Charyne and I, we talked a lot about how STRIMS 2 is going to impact data transfers. So these laws aren't going anywhere. And as far as the impact on companies, I mean, just take a look at some of the largest companies. Wired Magazine, I was reading, they did an article on Amazon and some of their data handling practices. We know, TikTok is under scrutiny for children's data, Google, facial recognition. We all know about, Meta and Cambridge Analytica, and then in the public sector as well. We see governments getting breached. Our federal government, that dealt with a hack. We saw universities deal with the Blackbaud hack. I think that was last year. And then, of course, as Ali talked about, the impact of Apple's privacy changes on the ad tech sector. So I feel like it's more of everything that you just heard, the impact, and it's also present in the boardroom. And Rizzy can probably tell you more about, what's going on with executives in the boardroom and how they're talking about this kind of stuff. Yeah,
and we know that a lot of these different privacy laws typically contain some type of provision in regards to data breaches. And Riz, I know you've done a lot of great work in regards to data breach investigations. Could you tell us a little bit about some of what you're seeing regarding those investigations, and maybe what are the regulators' expectations and what they think should have occurred to have prevented it, or just in regards to reporting and things of that nature?
Thanks. I think Stanton hits on an issue. You brought up Blackbaud, and I dealt with the fallout of that on behalf of a couple of clients, and that's one example where they utilized a law firm and probably didn't do a great job of protecting the privilege related to their investigation. A lot of that had to be disclosed as part of the MDL litigation in California. I'm going to say something controversial, but I'm not really afraid of doing that. I represent a lot of audit committees of public companies. That's just the nature of the types of people who are often calling me to conduct investigations for all kinds of corporate misconduct. There's a great opportunity for young lawyers, students of color specifically, in places like Howard University School of Law and our larger audience, because overwhelmingly, those people in those boardrooms are white males, elder white males, who don't understand how data is gathered, how data is used, what their own company is doing with data. So to answer your question, Charity, and to Stanton's point, there's great opportunity, and what I find in this space is an opportunity to educate, really to use your understanding as being younger in comparison, and understanding of how data works and how data is utilized, because informing these directors, these officers, who are all very accomplished people, about the pitfalls of misusing data, and also the exposure points that may exist, and the opportunity that data provides, is a key sort of component in understanding the whole sort of world of data and data privacy and what it could mean. So in my work, it's oftentimes, thankfully, not always related to data breaches. I'm not only going in a reactive way because something bad has occurred. Now more often, I think there is a willingness on the part of boards across the country to have counsel come in on the front end to provide counseling, to educate, to ensure that, hey, this issue that happened with Blackbaud, we don't want that to happen to us. And by the way, if there's a ransomware episode, how do we handle that? And this is especially true in light of what's happened at the current DOJ, and the focus by this Department of Justice and certain regulators and other agencies on ensuring that they're going to hold corporations' feet to the fire. They're going to want them to make notifications early, because they're putting the entire cybersecurity network of this nation at risk if they are not responsible in how they're handling the data of individuals. So that's what I see coming across, and it's an exciting area. And I hope that the students can learn that we're all different disciplines on this panel, and that's the beauty of this tech law space, that there are so much opportunity for so many different types of lawyers with so many different backgrounds.
Awesome. No, thank you so much for that information, Rizzy. So we just want to use our remaining time to go into the Q&A portion. For all the attendees, if you have any questions, please feel free to raise your hand in the raise your hand function. If you want to ask a question live, or you can feel free to put it in the chat, and we will be more than happy to answer your question. So while the questions roll in, at this time, we can just briefly discuss where do we think things are headed next. So if any of the panelists are happy to answer that question, we can discuss that. once the questions start rolling in, we can jump to the questions. So, yeah.
I can jump in. Yeah, I mean, I think, you know, as I was mentioning earlier, I think, you know, we've had 3 states so far pass privacy laws in the U.S. We're in the midst of another one, Utah potentially passing one, you know, it passed and the governor signing into law soon. I mean, this patchwork, I think ultimately it's going to be unworkable for companies, and I don't think it's necessarily good for consumers either. And I think we are heading to a federal privacy law. And you know, it's going to be, it's an interesting issue because the big dividing lines there tend to be between Republicans and Democrats, or whether the law is going to have a private right of action and whether it's going to have preemption. So it'll be interesting to see how those issues get resolved. But eventually, I can't imagine us having 50 different privacy laws. I think we are going to have a federal standard. It just comes down to what it's ultimately going to look like.
Yeah, no, thanks for the insight, and I agree with that as well. And I know we briefly also talked about the ad tech space. We see many different organizations are proposing different solutions and alternatives to the use of replacing third-party cookies. What do we think may be next for in that sense? Dominique, I'm happy to hear your thoughts in that area.
You know, I think a lot of the solutions are sort of putting I try to use an analogy, lipstick on a pig, or just a little Band-Aid on a huge wound. You know, the ideas that I've heard so far are not ones that will really address where I think the regulators and where actually consumer sentiment is right now. So there's a lot of work that the ad tech community has to tackle. I've heard of things like using loyalty programs and sweepstakes and signups and newsletters to try to encourage people to opt into receiving data. The issue there is in California, for example, loyalty programs. We just heard our California State Attorney General on Global Privacy Day on January 28th saying he's going after companies for their loyalty programs if their loyalty programs are not if they're not valuing the data and putting a notice financial incentive, which is required by the CCPA and it's going to be required by CPRA. So what I think is critical, and going to Rizzy's point, I'm so excited to talk about the boardroom. There, in order for companies to make these strategic decisions and lead in their data, they need to know where the parameters of the law, where the parameters exist in the law. And many times they're not lucky enough to know to call a Rizzy or anybody here, you know, Ali, Stanton, you, Charity, etc. And so they're in the dark trying to make these decisions without the benefit of what everybody here, and I'm sure you as students even know about where the parameters are. So I've seen some options being thrown out, honestly, that will create different and fresh problems. So I think this is going to be a conundrum that just needs to really be worked on, and it's going to be imperative for companies to be able to express the value proposition to consumers for sharing this data and really making it clear what they get out of this, why this is good for them, and then really the limitations on the use are so critical, as you guys talked about.
Got it. No, thank you so much for that information, Dominique. And we do have a question where someone said, for someone interested, or Charlie asked, for someone interested in getting into data privacy, do you suggest obtaining a CCPA certification? And for those who do not know, what is that? So I know for a lot of us on the panel have different IAPP certifications. So would anyone be happy to explain whether if someone is interested, should that be something they pursue, and providing information on that?
I think it's a really great thing for you to do as a student, and you're already used to studying, and the exam, literally, it's like basically 2 weekends of study, maybe 100 pages or 200 pages of books, stuff that you need to read, some sample exams, but it'll be a piece of cake for you guys. And I've noticed that a number of students like Santa Clara and others have programs where the students are getting their certifications to be a certified information privacy professional. Those certifications are issued by the International Association of Privacy Professionals, IAPP.org. And frankly, you know, it makes your resume sort of pop out and stand out if you've taken that extra step. If you can sneak it in while you're still in school, all the better.
Yeah, and students, you might want to look at the LinkedIn profile of this guy named Charlie Bingham, who has that same certification, and he's crushing it. So,
no, that's hilarious. So, I know I've been asked. This is just a question that I know many individuals have, whether in law school or maybe worked before law school, or maybe a year or two out of law school. Do you have any advice for individuals who are looking into switching into the privacy field, where how can they leverage their prior experiences in order to enter into the privacy realm and the privacy world that we just discussed?
I'd say for this one, just keep doing what you're doing. I mean, if you're watching this panel, you're learning, feel free to reach out to me, and I'm sure other panelists will be open to it as well, to learn more about our day-to-day. You know, I learned by talking to people, so I was big on getting coffees and setting up Zoom chats with people to just learn more about the space before I delved into it. And, you know, it made me feel excited. So, you know, I was ready to, you know, learn, and I got my SIP, and I actually subscribed to all the law firms and think tanks blogs who do privacy work. So I was constantly every morning, you know, as I enjoyed my coffee, you know, staying up to speed on the latest developments.
And I will also say the IAPP has a diversity and privacy Zoom call that I helped found about a year ago. And once a month, folks get in there with mentors, and it's a group Zoom, and it's a great way to talk both with new people who are students just coming out, and others that want to do a pivot in career.
Awesome, awesome. So I know we're about at the hour to conclude. So before we finish this discussion, are there any final words for the students, that anything that we want to leave them with before we end this session?
I would just like to say that this is just going to be an exploding area. So if anything that we have said today excites you, stimulates you, interests you, I would just encourage everyone to go for it. There is going to be so much work and help that companies will need, and your intelligence, your thoughtfulness, and your willingness to dive in, there's no dearth of work, and I think a really interesting, exciting area to jump into.
I agree. I second that. I've started to see privacy become a differentiator for companies, and for people who have even a baseline understanding of privacy, it's very valuable, because as you saw it today, it touches so many areas in basically anything that involves data, which is everything now. So even if you decide you don't want to do it later, I think just having that baseline knowledge is valuable.